The court will now proceed with the next case, Sievers versus the state of Florida.
Just in case.
May it please the court. My name is Karen Kinney. I represent Mark Sievers in this capital
Ms.
direct
Kenny, could you
appeal.
pull the microphone down a little bit? I think
Okay.
that'll give you better coverage
Is that
there.
better? I'd like to reserve 5 minutes for rebuttal. The state had a problem in this case, and the problem was that the entire conviction of Mark Sievers depended on the jury crediting the testimony of one witness, Curtis Wright. And the problem that the state had is that Wright was essentially a bad witness because he had previously made statements to the detectives that Sievers had not hired him, that he knew nothing about any marital difficulties with the Sievers, and he went into his plea proffer with the detectives and the prosecutors, and he told an inconsistent story from what ends up being his story at the trial. He told them that he was actually not present at the time of the murder, and that Jimmy Rodgers did the murder alone. And it's only halfway through that proffer that he changes the story when they tell him he's not being believed. And at that point, he says he prayed, which we objected to. That was overruled. He said he talked to his attorneys, and he came back and decided to tell the truth. So the state approaches this case by putting up front on direct in their case these prior inconsistent statements with the attempt to convince the jury that now that he's made this deal with the state, he is going to be telling the truth. So there's an inherent vouching for his credibility just in the fact that they gave him the deal.
How is that not true then of every cooperating witness?
Well, I don't know that every cooperating witness has made inconsistent statements and has made a plea agreement that, obviously the state uses cooperating witnesses, but this case is rather unique because there's no corroboration.
What about Rodgers' cell phone? That moves through traffic, right? That corroborates the movement of Mr. Wright and Mr. Rodgers, doesn't it?
There is plenty of evidence that Mr. Wright and Curtis Wright and Jimmy Rodgers did this crime. So the state did not need to make a deal with Curtis Wright to convict Wright or Rodgers. The only reason it needed to make a deal was to get to Sievers because it had no evidence that tied Sievers to the crime without Curtis Wright.
I understand that argument. I guess where I'm losing you is I don't understand why this is all that different from any other case where the state has conferred a benefit on a cooperating witness who has changed his or her testimony, which I think you'd struggle to find a cooperating witness who didn't change his or her testimony over time, didn't engage in some progressive truth-telling. So help me understand the limiting principle of the rule you're asking us to adopt with respect to Mr. Wright.
The rule I'm asking you to adopt, where I'm going with this are the evidentiary errors that occurred when, so Wright tells them that Sievers is not involved. So in order to take his deal, he has to renounce his prior official statements in police interrogation. In order to take, and this deal gives the state the right to find that he has breached the agreement, even after he testifies, and he has no judicial remedy for that. So it's very one-sided, this contract that he's entered into. They can find that he breached, and he has no way of arguing about that. And the other thing was that...
And didn't Mr. Sievers' trial counsel try to exploit that weakness in the state's case by thoroughly cross-examining the witness about those prior inconsistent statements and his motive to lie and all of those things? I mean, the credibility issues were played out in front of the jury like you would expect in a case where the state has those problems, correct?
Well, no, because the defense was hampered, and that's where my first three issues go to that. Because what happened here was the defense was trying to show that the state had a contractual benefit in that plea agreement, which was being able to test right with a polygraph exam. And it declined to do that. And when you think about it, the reason it declined to do that was because they probably thought there was, if he didn't pass, then that would essentially scuttle the entire prosecution of Sievers. If there was any kind of exam result that showed that he was not being credible. And so that when they didn't, so the defense was trying to exploit the fact, which was a fair argument, that the state had declined to give the polygraph exam. And my first issue goes to that, because what happens is there's a pushback every time the defense is trying to make that point, and that's their key point. And so the defense closes his closing argument by asking the jurors, do you trust Curtis Wright, and would you feel differently if a polygraph had been given? Now, the jury leaves for a short break, and the prosecutors make an objection and convince the judge to address the jury when it comes back. And the judge addresses the jury and says, if Curtis Wright had been given a polygraph exam and he passed it, that result would not be admissible in this trial.
Counsel, can you tell me where is the error in that statement? Is that a misstatement of the law? It's not an opinion on the case. So how is that an error?
Okay, well, we have black letter law in Florida that a judge may not sum up evidence, comment to the jury on the weight of the evidence, the credibility of the witnesses, or the guilt of the accused.
But that's a statement of the law, unless I'm missing something.
No, I was wondering which category you were going to place this statement in among those.
Okay, this is not a statement of the law because, first of all...
Well, isn't it an accurate statement of the law that polygraph results are not admissible in evidence?
Well, that's not what he said. He said if Wright had been given a polygraph and passed it, that result would not have been admissible in this trial. And I'm sorry, I don't think that is a correct statement of the law.
You saying if he'd been given a polygraph and passed it, that would have been admissible?
Okay, well, the way that it came out that he wasn't given a polygraph was that Sievers asked the detective, was he given a polygraph? Sievers asked Wright, were you given a polygraph? And there was no objection to that.
Maybe I'm missing something here, but I think this whole thing about the polygraphs just seems like an enormous diversion and kind of an improper area of inquiry. Now, if assuming that the agreement did not exist, and Mr. Wright's on the stand, and Mr. Sievers' counsel says, have you taken a polygraph examination that verifies what you're telling the court today? That would obviously be improper, wouldn't it?
Yes. And
well, I don't understand why in principle this is different.
Well, I think that the trial judge had the same problem, but this is different because Because he is testifying under a contract, and there are contract provisions.
He's testifying under oath. He's testifying under oath, and the contract. I'm just can't understand how that affects why it's proper to talk about a polygraph when a witness is being examined.
Because the state put him on and said the reason why he's now going to tell us the truth is because he has promised to do so in this plea agreement. And the plea agreement was entered into evidence without objection by the state, and it has these provisions about them giving him a polygraph, and they declined to do that. So Sievers can't prove that Wright is lying, but he can show that he wasn't properly vetted with the investigative tool that the state had bargained for.
I'm sorry to interrupt you, but isn't that the bottom line, though, what Justice Lawson asked you about, is that the lying, the wanting to get his wife out of the problem, the kind of implication that the state was sort of willfully ignorant of, possible problems with the testimony. All of that was brought out through the questioning. It was argued in the closing. I mean, it was, it was completely there for the jury to accept or reject that view of things, and obviously they rejected it. So what's the problem?
Well, I disagree that everything was brought out, because one of the things that we weren't able to bring out was this entire video that has a lot of information in it, and also information about the wife.
The issue with the video that you talk about is this whole thing about the blip stuff. And that was asked about, both sides asked, I think both Wright and Levitt, about that whole exchange about the wife being a blip, and wouldn't, all the whole back and forth about whether it would somehow be in Wright's benefit to say what the state, to give this testimony in exchange for the wife not having any further scrutiny from the state. I mean, that was, again, putting aside the merits of all that, it was brought out and it was put in front of the jury. I don't understand how that video clip would have, what difference that would have made.
We were trying to put in the entire video. That's a short clip that he wanted to emphasize. That's all you have, but you have the transcript of the entire video. And that video has a ton of information in it they go through the plea agreement. The prosecutor goes into this whole situation with him where Wright wanted to.
And if I remember correctly, the objection at the time that it was sought to be introduced was hearsay. Is that correct? The transcript was used to. Okay, and.
Yeah, the state said that it was hearsay.
Right.
And the defense said, you've opened the door, and this shows his bias.
Is there an open the door exception to hearsay?
Yes, because the state asked.
801 what?
The state was saying, oh, he can't admit this because it's hearsay. And it wasn't hearsay, because we were not trying to admit it for the truth of the matters.
Was that argued below?
Yes. Yes, that was the argument, that the state brought this up before the jury had come back and said, the defense has just showed us a video, and they knew what it was. Everybody knew what it was. That the whole transcript had been put into evidence at Sievers' bond hearing years before, and the judge was very familiar with this case. And
okay, can you which issue are you talking about right now?
Okay, well, we've kind of gone back and forth, but there was this assertion that we had all of the ability to bring, to test Wright's credibility. And I'm saying,
I would suggest that we're going back and forth, because in response to questions about one issue, you're jumping to another issue and bringing up something completely new. So now what issue are you talking about? Because it's difficult to follow.
Okay, well, I mean, I can go to whatever issue you want to talk about, but if you're talking about why that video should have been admitted, if you go through the transcript of that video, even at the end of it, there's a lot of information in there that would have helped Sievers' case. And there's, even at the end of it, you can see in there that the prosecutors, they're helping Wright come up with his story. And at the end, they do put to him, the one thing they challenge him on is this fact that he called his wife from a burner phone at 11:36 the night after the murder. And that's put to him, and there's some excuses made about that. And they're getting him ready for testifying because they need him. He's the only person who has any information that...
Counsel, just going back, I think, to Justice Lawson's kind of original point, is it your contention that the cross-examination on this issue was insufficient? Because it seemed to be very extensive, and I think our question is just, what would this transcript or video have provided that would have been different? It seems like the same situation. You had this immense cross-examination, and the video would have just been the same evidence in a different way discussed. So I think that's our question, is what exactly was so essential in the video that was not already thoroughly discussed in cross-examination?
So the video comes up after the state has rested, and the defense did not have an opportunity to put evidence in during the state's case. So now it's the defense's turn to put on his case. And the state has already asked Wright, and he says, yes, I told the truth during that hearing, during that proffer session where this is the whole meeting where he's getting his plea agreement. Oh, I told the truth during that. So the jury should be entitled to see what this is, because it is there's a lot of information in there that they didn't ask Wright about. And there's a lot of information, and it's showing the relationship between the state and Wright. They go through the whole plea agreement. They talk about his wife. There's a lot more information in that did not come out in the state's case. The state very selectively brought out facts during their case.
Okay, so I'm now tracking with you on issue 5, which I believe is the only place that you brought up a challenge to the trial court's sustaining the objection to introducing the entire video. Is that correct? That's in context of issue 5?
Yes.
Okay, and in issue 5, that is where you were talking about the blip, and so portions of the transcript were used to cross-examine witnesses. Is that correct? Throughout the trial?
Portions of the transcript.
The transcript from the video that you wanted introduced later were used to cross-examine witnesses, and statements were used from that transcript, correct? It's in the record. It was used at trial.
There was some cross-examination on these statements.
Skip
yes.
that. At some point, counsel offered the video into evidence, wanted to put the whole thing to evidence. There was a hearsay objection. Is that correct?
Yes.
Okay. And what was the hearsay exception that was offered in argument to the trial judge?
That this showed bias.
Okay, and that is not a hearsay exception, is it?
Well, it's a different...
Is it a hearsay exception? The objection is hearsay.
Right.
Trial counsel is responding to the trial judge and asking, what's your response to the objection? He says, well, it's offered to show bias. That does not address the hearsay objection, correct?
The proponent of the hearsay objection, so it is a separate grounds for entering a piece of evidence, and the hearsay will not defeat it, because the defense has a constitutional right, to show bias on the part of the witness.
So you're saying that the rules of evidence do not apply if the purpose of submitting the evidence is to show bias? That's your argument to us as to why the trial court was incorrect in sustaining the objection?
It wasn't hearsay, because it
was
wasn't
that argued
being
to the trial
offered.
judge?
Yes.
It was not argued to the trial judge. The only thing that was argued was it's offered to show bias. You argue in your brief that it wasn't offered to prove the truth of the matter accepted. With
Well, it
no,
was being
no,
offered to show bias.
okay.
So it was being offered to show bias, and and the state had opened the door by asking him if he had been truthful in that hearing.
But you recognize bias is not a hearsay exception, correct?
If you're talking about the list of statutory exceptions, I'm assuming that,
The video was an out-of-court statement. There was a hearsay objection, correct?
yes.
Okay. And based on the argument to the trial judge, the response was, well, it offered to show bias. And you're arguing that the trial judge was incorrect in ruling on that objection?
Yes, because we had a right to show that the bias was his relationship with the state. And that was coming out through this whole video where he's making this deal with them to testify and change his story to satisfy what the state wanted from him.
Let me go back to Justice Grossan's question from a while ago. What in the video that you would, if admitted in evidence, would it have shown that you did not somehow present in cross-examination?
Well, I could probably write a whole entire brief on that because it's a 200-page transcript, and there's a lot of information in there, and
That's why I'm asking you the question. What specifically would it have given you that would be that was prejudicial to your client? That would that was an error here.
They're going through, at the beginning of the video, they're going through this plea agreement. The prosecutor is telling him then that, we have this information about your wife, and if you're not going to go along with this, I'm going to tear this up. And the entire scenario shows that right is against the wall, and then they go through very carefully over and over again this story, and they're very friendly with him. They help him make excuses and craft this story. And at the end, they even ask him about, they've figured out that his wife had this burner phone and there was this communication, but they help him make an excuse about that. Oh, you were just married and you're probably just calling her to say hi.
So what specifically facts are in that video, not on cross, that would be a winner for your client, that would cause us to reverse this case? Don't tell me what the whole video shows. What specifically is prejudicial error by excluding the evidence?
Specifically, the relationship between the prosecutors and Wright, and his.
So in legal terms, how is that prejudicial?
Because he was a biased witness who had to satisfy the state. He wasn't an unbiased witness. He was a biased witness.
But it was known that he had a deal, right?
But this is the best evidence of this deal, and more, the involving of his wife, and it wasn't just that he signed a piece of paper. It was how this whole thing came about, and what they knew, what he was telling them. There was a lot more in that, and so I mean, that alone should have been admitted, and that was a big part of Sievers' case. But I really think that you shouldn't overlook this this argument that he had about the polygraph. And when the judge was making this comment to the jury, it was strange because it's not really a legal instruction. It's rebutting it's rebutting the argument that Sievers' counsel had just ended with on closing. And it's delving into the credibility of Wright, because it's telling the jury that something that was just happened in closing that Sievers was relying on, the fact that they didn't give him the polygraph exam, should be considered as not having done all of their due diligence before they put him on. And then it's rebutting that by saying there's something wrong with that argument. And it's going into the facts because the facts are the fact that he didn't get the polygraph exam that the state had bargained for. And it's going into that by invading the province of the jury and telling them essentially that they shouldn't consider that fact. So there are a lot of issues.
I do question your characterization there, that the judge told the jury, you can't consider that, because the judge allowed the argument and the questions about the agreement, including the fact that the state did have the opportunity to conduct the polygraph exam. Is that correct? I mean,
The
Yes?
without
Is that correct or
objection,
not?
I mean, allowed without, right, there was no objection to
Okay.
the contract going into, plea agreement going into evidence.
Okay.
So they had that before them, and they had the information that he was never given one. So for the judge to say, if he had passed,
Reading the whole line of question, what was said about the polygraph in front of the jury, they could have been led to believe, seems to me, that polygraph results are admissible. And if the state had just done that, then the jury would know that the polygraph result. And is that correct? I mean, that's...
well, we never said that. I mean, the issue was, did they give it to him? Did the state use their investigative tools to give it to him? So it was and Sievers' defense said, we're not making an issue about admissibility. The question was, did they give it to him? And so when the judge
Right.
delves into this, okay, polygraph exams, the general rule should be that it's, and I believe it is, that they're not admissible to show the guilt or innocence of the accused. And this was not being used for that. This is different, because this is a witness who the state is using and has made a contract with and used that as a provision of the contract. So the question here on admissibility of whether a witness who makes a contract and whether or not their test result would be admissible, I think it is incorrect to say that if he passed, it would not be admissible, because the state the defense can ask him about that, and no one's going to object if he passed.
You really think the law in Florida is that if he passed the polygraph test, that the jury would get to know that? That's exactly what you just said, and you really
wouldn't
think that that's
object to
true?
it.
Well, if the defense asked about it, if the defense asked the questions that it had asked in this trial, then the result would have come in. They asked, did you give it to him? So not necessarily the result, but
Wouldn't that be ineffective assistance of counsel if you skillfully maneuvered to get admitted a polygraph result that shows that this witness that is adverse to your client was telling the truth?
if the question, okay, they're putting him on as someone who's telling the truth. So if and they're saying, he's telling the truth. So if they say, did you give him the polygraph? And the answer is yes, well, we're not necessarily going to go to whether or not he passed, but if he didn't pass, then they probably wouldn't have even been having this trial. So the question...
Ms. Kenny, you have used most of your rebuttal. We've helped you.
Okay. I'm sorry.
We get through that. But what I will do is I'll give you 4 minutes for rebuttal.
Okay, thank you.
Good morning, Your Honors, and may it please the Court. My name is Christina Pacheco, and I represent the state of Florida in this case. Your Honors, the problem that Ms. Kenny states is the main problem with this case is not a problem at all. As Your Honors acknowledged Curtis Wright was, the jury knew all of this information about Curtis Wright. The jury knew that Curtis Wright entered into a plea agreement in exchange for his testimony. He was getting 25 years. That was never hidden. That was the defense's theme throughout the trial. The jury knew about the inconsistencies in his statement. The jury knew that he initially lied to law enforcement and said he wasn't involved, and then he, once he was arrested, he gained counsel. He talked to the state and for a plea statement, and then during the plea statement, there were some inconsistencies. The jury knew about all of these times that Wright was inconsistent. The jury knew about the terms of the plea agreement, and when the agreement was entered, the conversations about the prosecutor and his wife being a blip on the radar. The questions asked of Wright during trial included the fact that he was concerned about his wife before he entered into this plea agreement. Of course, he would want to do what he could to protect his wife. All of that was brought out during cross and recross, and also the detective's testimony. So the jury knew all of this information, and they chose to believe Wright. On appeal, there's really nothing that we can do about that, as your honors know, in terms of the fact that the jury chose to believe Wright. In terms of the judge's instructions, Justice Grosshans and Kennedy both acknowledged that the judge's instruction to the jury was just a correct statement of the law. I'd like to point out that it wasn't actually preserved, the argument that this is an incorrect statement of the law. That was never preserved, but more importantly, it's the judge's role to instruct the jury, and the judge merely said that if Mr. Wright had actually taken a polygraph, those results, if he had passed, would not have been admissible during the trial. And there's nothing wrong with that statement. It is correct. If Wright had passed a polygraph and the state used that during trial, I submit we'd be up here arguing that fact. I don't agree with Ms. Kinney's statement and this being an incorrect instruction. And I think that it was proper and warranted given the implication of defense counsel's argument, and it left the jury with this implication that Wright needed to have a polygraph conducted in order to show that his trial testimony was truthful. So under those circumstances, it was warranted to correct that implication. But in terms of Ms. Kinney's argument that the defense was hampered regarding the polygraph, that there was no way that the judge hampered the argument in any way. During the trial, that was the defense's main theme, and it played out throughout the entire trial that the Wright entered into this plea agreement. The state, with a plea agreement, had the opportunity to give Wright a polygraph exam, and the state chose not to do so. The defense was never precluded from asking any questions or making any argument regarding that fact of the plea agreement. So that came out throughout the entire trial. In terms of, I believe that addresses all of the issues. Is there anything that the court wanted to discuss?
Can we go to issue 12, please?
Sure.
State's contention that it showed good cause for the updated notice under 7-8. You concede that there was no showing.
Yes, Your Honor. It's our contention that the state did show good cause. The judge found that the state had good cause to amend the notice.
What was the good cause?
The good cause was that the judge found that what was pleaded in the state's notice or motion to amend, and the state said that the delay was inadvertent. It was just a matter of 5 days between the original filing of the notice and then the motion to amend, which included the inclusion of the aggravating factors and that nothing had occurred during that time frame in terms of discovery or case preparation, and there would have been no prejudice to the defendant.
That suffices as a show. Doesn't good cause that there is a justification as opposed to an explanation of, it sounds like you're saying it was just tardily filed, oops, and the court then found good cause shown. I'm a little concerned about that as a basis for finding good cause shown. And I'm curious if there's a case you can direct me to that would say that this finding is in fact sufficient as a showing of good cause.
Well, Justice Coriel, I understand your concern, and the judge found good cause based on those reasons. I believe there was a case cited in my brief that dealt with a clerical error, and that was the reason why there was a mistake in a notice. It wasn't under the statute, but it was a clerical error. But I think the more important matter is that while the judge did find good cause, the spirit of the statute was the state complied with that. There was substantial compliance with the notice.
I'm not sure I would argue about the ghosts inhabiting this statute. I would deal instead with its words. And I guess my question for you is, isn't your better argument to tell us what kind of discretion we should be giving the trial court here? What do you argue that our standard is on this?
The standard is abuse of discretion, and that it was within the judge's discretion to find good cause. He looked at all of the circumstances. He held a hearing. He listened to the argument from parties, and while the judge the state didn't really elaborate on the fact that it was inadvertent, it was, the statute did just change, and it was just a matter of days that the state realized and added the addition of the aggravating factors. So
it is, though. I mean, I think this is kind of a messy issue for you, though, in the sense that the discretion, it's bounded. I mean, so first of all, the statute doesn't say anything. We have our rule that's kind of the counterpart that talks about good cause. I guess if we read the rule and the sort of the baseline 3.050 about extensions of time, and it talks about good cause on the front end and then excusable neglect if you've missed the deadline. And I think what Justice Coriel's questions are getting to from our perspective in terms of precedent, it seems like it would be a stretch for us to call this either good cause or excusable neglect when just looking at the record fairly, it seems like the prosecutors just weren't aware of the new law or forgot about it or whatever. The initial notice only referred to the discovery thing. And so it seems like if we get to the end, so there was even though cert was sought, that didn't happen. So we get to the end, arguably we default to the harmless error statute. Obviously, if the question is just, was there prejudice, it seems 100% obvious there was no prejudice. But whatever we say about this seems like also has to inform what courts would do if it were taken up in a cert proceeding. And it seems like, in this case, you basically just had a sort of dropped ball situation, and you have a notice that was really kind of, I think, I'm not even sure if you can get to the amendment issue when the notice itself is so defective in the sense that, you're supposed to say that you intend to seek the death penalty and what the aggravators are. If you don't even have the aggravators in there to begin with, then I think you could argue that it's the same as essentially not having given notice at all. And so you're not even, if you're working under the world of the statute, you're not even in the amendment category because, you can't seek the death penalty if you don't know that you're going to be able to prove an aggravator. And if you don't say what the aggravator is, then have you even really sort of given notice on period? So help us kind of think through, what we say about this that could inform not just in a situation like this where it does go to the end and you arguably can do harmless error, but if it is taken up in a cert petition, would the right answer at that stage have been that the state's out of luck and there's no possibility of the death penalty in this case?
Well, no, Your Honor, because the statute does permit the amendment to occur. So I think if If there was no, if the state would be out of luck and there's no death penalty, I think that that should be expressly provided in
So
the statute.
upon a showing of good cause. So we would have to say that that essentially ignorance of the new law is good cause for allowing an amendment.
Or your honors could find that if your honors did not believe that the state or the judge's finding was correct in finding good cause, that the error was harmless and there was no prejudice, and that the state substantially complied.
And that's the problem. So that solves this case. But it seems like when you're at the cert stage, you don't get the benefit of the harmless error safety valve. They have to decide it on the merits then. And if this case had been decided by whatever DCA it was at the cert stage, if they hadn't dismissed it, would the right answer have been, sorry, state, you either can't meet good cause if we only look at the statute, or if we look at the rule, you can't show either good cause or excusable neglect?
Well, I think that we're assuming that I think we have to jump and make an assumption that the state, the issue is that if you're not agreeing with the judge's decision, but the record is really, other than the state saying it's inadvertent, I think we're making conclusions as to why the notice of the aggravators was not included. So
Right.
I think,
And the state I think it's in its response to the motion to strike, it said, basically it focused on the absence of prejudice, which seems like that's a separate question from good cause.
Yes.
Good cause is looking at kind of what was affecting the failure to file or the need to amend. The absence of prejudice is kind of a separate question. So it seemed like by focusing on that, the state was kind of, they said it was inadvertent, and then they moved straight to the absence of prejudice. We obviously don't want a precedent that says just inadvertence is good cause, right?
yes. I think then the record needs to be expanded in terms of what went wrong. I think that we can't really read into it in terms of why it wasn't included other than it was inadvertent. But I understand the concern. However, I think that if this court wants to give instructions as to what should be involved with a finding of good cause, that would be completely understandable. It needs to be a more elaborate finding. But I think in this case, the ultimate conclusion should be that it was harmless under these circumstances of just the 5 days between the initial notice and the amended notice, and it was over 3 years between when the aggravators were provided and the trial occurred. So the purpose of providing the aggravators to prepare for trial, it was not hampered in any way, and the purpose of notice was to substantially complied with the spirit of the statute, and it did not prevent.
Has there ever been a case from this court that addressed this situation?
I don't believe so, Your Honor. I would be happy to conduct some more research and provide any cases that maybe may help this court in reaching a decision. The only case that I know of from this court dealt with the retroactivity of when a case goes back for resentencing after Hearst, and that obviously is not the situation here, but I'd be happy to conduct further research on the issue of good cause and supplement it for this court's review. Are there any other further questions? The state therefore respectfully requests that this court affirm the defendant's convictions and sentences.
Thank you. Rebuttal argument.
On the issue of the state's notice, the state filed their notice after Sievers moved to strike their 3.202 discovery notice, and it filed it the same day. So that was 49 days from the May 9th date and 53 days from the May 5th date. And
So should we just kind of go with the spirit of the statute and say that even though under your theory their arraignment was waived, that we should act as if there were an arraignment and that it happened 4 days before the scheduled date?
Well, under the case law at the time, the waiver acted as the arraignment.
Where
So, but-
where that 1 second DCA case where the court said we don't see any reason why. I think the extent
Yes.
of its quote unquote analysis was one sentence where it says
Right.
we don't see any reason why we wouldn't start the clock now.
Yes. and
But
that
so it
would
seems
be
like
the-
you're asking us to be, and I like formalism. I like sticking to the letter of the law, but you're asking us to be, hyper formalistic with the 45-day thing and saying that, the amendment, it's not even an amendment because the notice was defective, but then we're supposed to ignore the fact that on your theory, there essentially wasn't an arraignment, in which case, if there wasn't, then arguably the statute doesn't even apply.
There was a day where he was brought in after the prosecutor told the judge that his written plea of not guilty actually wasn't a written plea of not guilty.
Right.
So he's brought in on May 9th, and the state
Okay,
doesn't
so,
file
but
at
hold on.
782.
I'm sorry to interrupt you, but if you're going to go down that path, then there was an arraignment. The initial notice was timely, whether it was kind of fatally defective for not having had the aggravators. I think, isn't it conceded that if you start with I guess, May 9th or whatever the date was, and you start the 45-day clock from there, this notice was issued on day 44.
His Rule 3.202 notice.
Right.
Which had no aggravating factors in it, which
Okay.
wasn't under the statute. And I'm saying you can't relate back to that because that wasn't the notice that the statute requires. They need to relate back to that, and then they need to say that he had good cause to amend. So they
Right.
need to take two leaps.
So can you tell
get
us?
there.
Can you tell us why? And I completely understand if we focus on the front end. I understand the arguments you're making, but why? What reason would our court have for not defaulting to the harmless error statute, where the legislature in 782 whatever is silent on a remedy, but it does tell us this? It does have this kind of catch-all remedial harmless error statute. What basis would we have for not applying that here? Because you agree that if we do look at prejudice, there's zero prejudice, right?
Well, I don't think that that's even a consideration.
Okay,
because-
right. So
yeah.
you think the harmless error statute shouldn't even apply. So tell me why.
No, because this is a legislative a time bar that I don't think that how can you make a harmless error analysis?
Well, are you saying it constitutes fundamental error?
I'm saying that it's a time bar that the legislature put in place as a benefit to the defendant. And I don't think that there's any room for, it's almost like a jurisdictional bar to the death penalty. They have to meet this time bar. And there's no wiggle room there unless
So,
you're going to
Counselor,
make
you
some.
view this like a statute of limitations type issue, where if they
Yes.
file after, there's no harmless error because there was no jurisdiction.
Yes, for the death penalty. That's how this court should apply it, because it's not gray.
You've used your time up, but you can
Okay.
take another 30 seconds to sum up.
Okay, I just want to say that without Curtis Wright's testimony, the state has no evidence that Sievers was involved in this murder. And a number of errors that were discussed in the first part of the brief, they combine to bolster the credibility of Wright. So I'm asking this case to reverse for a new trial, because these errors enhance the jury's view of Wright's credibility and give undeserved credence to his story. And it should go back for a new trial with the understanding that this should not be a death penalty case. Thank you.
We thank you both for your argument in this case today. The court will now stand in recess.
All rise.